Good morning. This is a short video clip on the contract law class exercise set on Tuesday, the 23rd of February 2021 for my Year 2 AQA A-Level Law students. Now, the first question, as we went through on Tuesday, is based on your understanding of counter offers. Now, in order to answer the question effectively, you've got to remember the assessment criteria. So the key command word here is explain. So essentially, you don't need any cases to support your answer, but it's always a good idea to get into the habit of supporting your answer with cases. So the question is all about counter offers. Somebody inviting, that's a key point. So how do you start your answer? You would briefly explain what a contract is. So a contract is a legally binding agreement between two or more parties that the courts will enforce. And then the next thing to identify is that, generally speaking, advertisements of a bilateral nature are invitations to treat. So when one of the parties suggests that they intend to sell an item for a particular price through an advertisement, that is actually an invitation to treat. And as you all remember, an invitation to treat is simply an invitation to another party for them to make the offer, and then the seller is in the driving position to decide whether they want to accept or reject that offer. So the key legal authority that suggests that advertisements are invitations to treat would be the case of Partridge and Crittenden. Then if we have a look at the fact that the other party suggested a lower price, that's a counteroffer. So in your answer, you would clearly state that a counteroffer has the effect of cancelling out the original offer. So it doesn't matter that the person then, the potential buyer then re-offers the same price being asked by the seller. That's a fresh offer. And with any offer, you can either accept or reject. And the key point here is to, again, support your answer. Always good practice to support your answer with a case. And the case for counteroffers would be the case of Hyde and Wrench. Now, for those who want to expand their answer further to get even higher marks, you would then talk about the case of McLean and Stevenson to suggest that a request for more information is not a counteroffer at all, but rather just more information as to how payment may be made. So the key summary is the fact that there is no obligation on the seller in the first question to accept the same price being asked for. So that will be your conclusion for question 1. Now, question 2, again, is all based on rewards. So to start off question 2, you would simply, again, you can briefly touch on the definition of a contract if you want, but the clear emphasis here is, again, to test your knowledge on the understanding of advertisements. The general principle in contract law is that all advertisements of a bilateral nature are invitations to treat. This is slightly different. So it's an advertisement made by electronic means or on social media. And the key thing to remember is that it's what we call a unilateral offer, which simply means it's an offer for a reward. So you would clearly state that the case of Partridge and Crittenden doesn't apply here because of the nature of the advertisement. In Partridge and Crittenden, the advertisement was a bilateral offer or contract. In this particular instance we're looking at here, you've got an advertisement offering a reward. So the key case here is the classic case of Carlisle and the Carbolic smoke ball, where an advertisement was issued for £100 to anybody who used the smoke ball correctly, yet still contracted influenza. So the key point to mention here is that the advertisement on Facebook was one of a unilateral nature, which means that the person who puts out the advert is asking for performance of a particular act. And that performance of a particular act will be the return of Hugo, the missing dog. So your key case here, and don't forget the command word in question 2 is suggest. So there are two aspects to the assessment criteria. The first one is explain, 2 marks, and the second one is application, which is 3 marks. So whenever you get your 5-mark questions, remember question 6 is always explain. The whole AO1 is just for 5 marks. Question 7 again is suggest, and the key point here to remember is that the assessment criteria is split into 2 parts. The first part is the explain bit, which is 2 marks. The second bit, AO2, is apply. So the key case to mention here would be the case of Carlisle and the carbolic smoke. But make sure you expand on that case and explain how it relates to the current question that you're dealing with. So the emphasis would be that once the other party returns the missing dog, then the issuer of the advertisement or reward is under an obligation to pay the money. So that's why you would suggest that the person who puts out the advert would not be able to deny the reward to the person who returns the item. So that is a quick summary of what you need to think about for question 2. The final question is question 3, and again we're still emphasizing on offer and acceptance. So question 3, opening answer, is an explain question, so everything is based on explaining the law relating to offers and invitations to treat. So again, you've got the display of goods in a shop window. The case of Fisher and Bell suggests that the display of goods in a shop window is an invitation to treat. This particular question rather fits in nicely with the case of Pharmaceutical Society of Great Britain and Boots Cash Chemist. The key emphasis from this particular case would be the fact that the goods on display are invitations to treat. It's not an offer. If it's an offer, then when you pick the medicine, the COVID-19 tablet up, then a contract is formed and there'll be nobody to supervise it. There'll be no pharmacist to supervise. So there would be an offence there. But that's not the case here, because based on Fisher and Bell and also Pharmaceutical Society of Great Britain and Boots, we all know that display of goods in a shop window are invitations to treat. So whoever picks up the medicine must then go to the counter and ask to buy. When I say ask to buy, the more appropriate word would be offer to buy the COVID-19 tablet, at which point there will be the cashier there who themselves might be a qualified pharmacist or chemist, or they would shout over the chemist to come over, check the details and see whether they want to sell or whether they want to, more appropriately, accept the offer. So that's a quick summary of question 3, and the emphasis will be on the case of Pharmaceutical Society of Great Britain and Boots Cash Chemist. I hope this short video has helped you to think about some of the key things you need to think about in answering those 3 questions. And if you have any further questions, please make sure that you message me on either Microsoft Teams or email. Thank you for watching this short video.